Please be seated. Call now cause number AP-77088, Gary David Green versus the State of Texas.
Good morning, Your Honors, and may it please the Court. My name is Thea Posel, and along with Raoul Schonemann, we represent the appellant Gary David Green in this case. This is an appeal from a conviction and death sentence out of Nueces County on change of venue from Upton County in West Texas. This morning, I will first discuss the issues related to the state's improper closing argument at penalty. Then I'd like to discuss the denial of the requested lesser included offense instruction, and I've reserved 3 minutes of my time for rebuttal. At penalty argument in this case, the state displayed a PowerPoint slide with data on it and told the jury that, I quote, "It's been 2,094 days since October 2nd of 2013. 31 Texas officers have died from gunfire. I segregated it out only for gunfire from 2013 till today. That's 10% of the nation's officers, 309 that have died." At which point, trial counsel objected, said that this was improper argument, there was no evidence of this in the record, it had nothing to do with Mr. Green or the case at bar, and it was improper under the 8th Amendment as well.
Counsel, would it have made a difference then if instead of no PowerPoint, he had just said how many officers have died in the line of duty from shooting this year alone? Wouldn't that be a proper plea for law enforcement? Why is it the extra stuff make it more prejudicial?
Well, Your Honor, this court has said that the injection of extra record evidence into closing argument is improper per se. There are 4 permissible bounds of argument at summation, including summation, reasonable deduction from the evidence, answer to an argument of opposing counsel, or a plea for effective law enforcement, but that does not include additional facts that are not in the record. So this court has before reversed cases in death penalty and non-death penalty cases. We cite the case of Lopez versus State in our briefing where the prosecutor made a comment.
Just mentioning that other officers have died from shootings, isn't that injecting evidence in the record?
Well, I would agree, Your Honor, and instead here the state went further. They researched, compiled, segregated, and presented these facts that were not in the record and urged the state by emphasizing this, or urged the jury throughout to return a verdict based on this improper evidence. So immediately after the objection was overruled, the state continued, spoke about the decedent Deputy Kennedy in this case, but then talked about law enforcement families more broadly, about their experiences and their joy and their pain when they lost their own loved ones. Then the state invoked the patron saint of law enforcement, St. Michael, pulled a coin of the saint from their pocket and showed it to the jury, saying, "I've carried this with me throughout trial. I pass it on to you. Life without parole is insufficient for Gary David Green. Don't let them down." And later, in rebuttal closing, another prosecutor invoked the slide from before, said, there's one victim in this murder, in this case, but as Laurie showed you in the PowerPoint, there are so many more. And then finally came to emphasize kind of misrepresenting the testimony of a defense witness to tell the jury that people who are convicted of killing a law enforcement officer do not get life without parole. So the state has already conceded that this argument was improper. The question for this court now is whether there was harm. And under both state law and federal law, there was. So when this court examines issues of extra record facts injected into closing argument.
What was the total percentage of time spent on this? I mean, there was a whole lot more to closing argument than just this.
Yes, Your Honor, and the state points out that it was a certain amount of lines in the transcript, but when this court assesses the severity of the misconduct and the prejudicial effect, it asks whether the argument was emphasized, not whether it was just repeated. And so the kind of return throughout this thematic use of other law enforcement deaths and what other law enforcement, other defendants convicted of killing law enforcement officers get, emphasize this improper argument. So one of the other factors that this court looks to are any curative measures that were taken. In this case, the trial court overruled the objection. And they issued no admonishment to the jury, like we often see, the arguments of counsel are not evidence, did not admonish the prosecutor for the argument. And so that potentially indicated to the jury that not only was this not objectionable, but it was a proper consideration when assessing the penalty for this defendant in this case. And finally, this court considers the certainty of the conviction or penalty absent the misconduct. And here, there were a number of reasons why the state points to in their brief the verdict could be sustained, but the sufficiency of the evidence is not the question.
I got a question. Is it inappropriate to talk about the impact of this type of a killing on society, so that if a jury, for example, wants to send a certain message, right? If you say this is really bad conduct, and we want to ensure that people know that if you get found guilty of this, that you are going to be punished severely, is it not appropriate to, and I'm not suggesting it is, I'm just asking your opinion about it, is it not appropriate to emphasize that this is happening a lot? Is that not proper?
Well, Your Honor, in Freeman versus State, the prosecution made a statement that the defendant had attempted to commit one of the worst acts against law enforcement in history. That was found to be improper, even though it was not a specific injection of evidence. This court has, in some cases, said that sending a message to a community is a proper request, but the specific evidence introduced here and the request for a verdict based on that, as well as the suggestion to the jury that people who are convicted of killing a law enforcement officer don't get life without parole, pled the jury not to let the other families of other law enforcement victims down by sentencing this defendant, in this case, to death, I think took it beyond not only a state law issue, but it infringed on appellant's right to an individualized determination of sentence under the Eighth Amendment based on the circumstances of this offense, his characteristics, his background. I think this court has also, in non-death penalty cases, found improper injection of additional data in
Excuse me,
response.
just
Yes,
a
Your
moment,
Honor.
please. Would we have visitors in the back that don't have a seat? Would some of the court staff give them their seats, please? Thank you. You can stand in the back.
Well, let me ask this. You mentioned the line, people don't get life without parole for killing a police officer. I mean, are you characterizing that line as no one else who's done this crime has gotten life without parole, or is there a chance that with the meaning of that statement is a normative statement, like you should not get life without parole for killing a police officer? Like,
Thank you for that question, Your Honor. The reference that I'm specifically pointing to was in the prosecutor's summation of the defense risk assessment expert's testimony, and he was asked on cross-examination about, certain studies, and then what he actually said during his testimony was that 2 of the studies had an insufficient sample size. He said one of the reasons for that was based on the way that the federal death penalty statute was written, and then the other sample was conducted just from a body of people who had been sentenced to death and were then resentenced to life, and in that specific sample size, there were not enough people who had been convicted of killing a law enforcement officer to make a statistical prediction. So it misrepresented the testimony and told the jury that, what did their expert tell you? He told you there's an insufficient sample size. What does that mean? That means that people who kill law enforcement officers do not get life without parole. So I think in terms of the question you pose, it is much more the former. In terms of the constitutional issue, the questions before this court are whether the clearly erroneous ruling that allowed the state to introduce this extra record evidence and argue from it, entirely unrelated to appellant in this case, and argue that he should be sentenced to death based on that, did violate his Eighth Amendment right to an individualized determination of sentence. And then whether that erroneous ruling and argument can withstand not only the heightened scrutiny that the Eighth Amendment requires, but the heightened review that this court applies to constitutional error and is required by Chapman versus California. The answer to the first question is yes, and the answer to the second question is no. Reversal is required. The state, in their brief, recites the evidence that is sufficient to support the verdict. And they say that they believe that the jury could have returned this verdict nonetheless, but that is not the standard. When we're assessing constitutional harm, it is the state's burden to prove the error harmless beyond a reasonable doubt. And given the pervasiveness of this theme throughout their closing argument, they cannot do that here. I'd like to turn to the denial of the lesser included offense.
Just before you go,
Sure.
one more thing was, when the objection was raised, was the Eighth Amendment invoked? in
Yes, it was,
particular?
Your Honor.
Thank you.
So, at the charge conference, the defense requested lesser included offense instructions. One of those were for the offense of murder. The trial court completely denied a lesser included offense at all, which creates both a Beck problem and an issue under state law.
Why isn't this just simply an analysis for whether the lesser included instruction was warranted. I mean, I don't see Beck as being, which is a categorical rule that says you can't completely foreclose a lesser included. But if the evidence doesn't raise a lesser included, and if the trial judge doesn't think the evidence raises a lesser included, then how do we even get to Beck if that's what we're dealing with?
Well, certainly, Your Honor. It's a two-step inquiry. So the first question is whether there was some evidence in the record, anything
Yeah,
more than a
so
scintilla.
What is your evidence? What is your scintilla of evidence on this issue?
Well, yes, Your Honor. So this court has said when you're looking at what is a scintilla, it is anything more than nothing. It does not have to be strong. This court does not have to find it credible. It does not have to be it does not have to be corroborated or uncontradicted.
I understand that.
So
But what evidence are you relying on to support that proposition?
Sure. Well, as the state has introduced, I believe, bench exhibits before this court, so you have been able to see that the law enforcement officers were dressed in what were called non-standard uniforms. They were not dressed the same. They did not arrive on the scene at the same time. The testimony of Deputy Stiles, who presented evidence at trial, said that Appellant was asleep when he approached the vehicle. There was testimony from both of the convenience store workers that the Appellant seemed to be having a bad day, was not quite making sense. There was a lay witness who approached the vehicle and was looking to buy a truck of that kind. So he was kind of walking around. He noticed the odd behavior of the occupant. He tried to get his attention. He wasn't responding. So when someone is charged with capital murder for killing a law enforcement officer, the state is required to prove not only that that person was a law enforcement officer, but that the defendant subjectively knew that. And there is evidence in the record from which a jury could rationally find that he was not sure.
What is that evidence?
Well, so we know that his state of mind was questionable. So a jury could find that he was not with it at that time. And based on the fact that he did not know what was happening in West Texas, he was not from there. There's evidence in the record that he was from Fort Worth. And the state made sure in their case, because this venue was changed here, they made sure to elicit testimony from the sheriff that this is the way we did it in West Texas, to be clear to the jury that these people were law enforcement officers. That evidence was not available to Mr. Green at the time.
So someone asks for identification and, whether he was just awakened or whatever, that doesn't, indicate that perhaps this is a little odd, that just somebody from outer space or whatever is asking for ID, and then the second officer has a flashlight and looking at the VIN, and I think the record indicates that they both had something on their apparel that indicated they were law enforcement. So he's asleep throughout this whole thing and doesn't see any of these indications that they're law enforcement?
I believe Deputy Stiles' testimony was that he woke him up. But so he handed the license to Deputy Stiles. That's evidence from which a jury could rationally find that Deputy Stiles was known to be a law enforcement officer to Mr. Green, but no other evidence exists to impute that knowledge to Deputy Kennedy. And is there evidence sufficient for the jury to convict him? There is, but we're not challenging the sufficiency of the evidence here, and this court has found that denial of lesser included offense instructions in death penalty cases is erroneous, overturn the sentence and verdict, even where they have simultaneously rejected sufficiency of the evidence challenges. So the question is just whether there was a scintilla of evidence, and it may be weak and it may be incredible to this court, but if it exists in the record, a lesser included offense instruction is required.
So your scintilla of evidence is that he was asleep?
Well, he was asleep, and there is evidence that his state of mind was confused. And this court has said the bottom, we don't really know what a scintilla is defined, but we know that it has to be something more than just disbelieving the state's evidence. And here, there is more than that. And so under state law, this court has imputed the rationale of Beck and reversed even where an additional lesser included offense was granted to the jury, even if the particular one requested by the defendant was also raised by the evidence and was not issued by the trial court.
So counsel, again, explain to me more why it is we even get to Beck instead of, if we think the evidence doesn't support a lesser included, it doesn't seem like Beck is implicated at all.
Well, certainly your honors would have to first determine that the ruling of the trial court was erroneous, and we believe there's evidence in the record from which you could so find. As I responded to Judge Hervey, there was evidence that his state of mind was not...
Right, but assuming we don't agree with that and we think that there isn't any evidence to support the lesser included, why is Beck important? Does it provide any extra emphasis for why he's entitled to a lesser included instruction beyond the analysis we would ordinarily do?
Well, in a death penalty case, Beck is specifically concerned with a jury being put to what it called an impermissible all or nothing choice to convict or acquit, particularly where the evidence is strong on most of the elements,
Right.
but there's a question as to one.
So you're saying that Beck requires a lesser included instruction even if it's not warranted?
Where warranted by the evidence
Okay,
and
well,
under
that's
state law.
exactly my point. Thank you.
However, I do believe that this court and the Fifth Circuit have noted that this error can never be harmless. And while this court's assessment of some harm under Almanza is close to that, we believe that Beck speaks specifically to capital cases. And so because evidence in the record could lead a jury to rationally doubt whether Mr. Green knew that Deputy Kennedy was a law enforcement officer, the lesser included offense instruction was warranted. And I would like to briefly point out this state has raised Williams in defense, saying that the evidence was, or the request was not properly preserved. But in that case, the judge specifically asked the defense counsel to point to evidence in the record. The defendant had testified in his own defense that he committed no offense at all. So the evidence that might support the lesser included was not apparent to the trial judge. The defense counsel did not provide it upon request. And this court in Williams noted that the lesser included offense is warranted whenever the evidence is pointed to in the record or it is manifest. And so because here there was a question about whether Appellant actually possessed the requisite subjective knowledge, there was no statement on his behalf. He was taken immediately to the hospital for surgery following the gunfight with Deputy Kennedy and Stiles. And so there's nothing in the record that goes to show that he knew or that he didn't know, but there is evidence that could lead a jury to doubt. And for those reasons, Your Honor, unless there are any other questions, I would cede the remainder of my time for my rebuttal.
Thank you, counsel.
Good morning. May it please the court. My name is Laurie English. I'm the 112th District Attorney out in Crockett, Reagan, Pecos, Sutton, and Upton counties. Good morning. So I want to speak to the points of error 6 and 7 that Thea started with. I conceded in my brief, I concede before you today that the argument about the officers who had died was improper. Follow my sword, it is what it is. It was improper. I do not believe that it was harmful. I think it was harmless under both standards for review. There's no constitutional error. The severity and the prejudicial effect of that misconduct, and although there were no curative measures made, I know those are the things that you look at to determine the severity of that mistake or misconduct, and the certainty of the conviction.
Did the judge give any kind of limiting instruction or additional instruction regarding that argument?
She did not. Okay, she did not.
Actually, well, was there at least a general instruction in the jury charge that says you're only supposed to make your decision based on the evidence presented?
I believe it was in the guilt innocence charge. I don't remember that it was in the punishment charge.
Fair enough.
The certainty of the conviction, absent the misconduct, is what I want to focus you on today. The appellant had quite a criminal history. The evidence was very overwhelming for the jury from the standpoint of he beat his mother and put her in the hospital and actually ended up serving time for that assault. He beat his ex-wife. He beat his son, and there are pictures in the bench exhibit for you. I'm sorry, not of those things, they're in the trial exhibits. I apologize. The bench exhibits deal with the lesser included part. The son had 6-inch whelps across his back. He was a teenager when this happened. And the slide that Ms. Posel keeps talking about, that the second prosecutor referred to, that slide was actually a photo collage of all the victims that had been harmed by the appellant through the course of his criminal career. His criminal career started when he was 18 with a public intoxication and exposing himself to girls in high school all the way to the day that we ended up with this
Why did we
happening.
even need the slide? Why did you even need to put the slide with all the details about law enforcement if you had all this compelling evidence suggesting death was important?
A bad judgment call on my part. So,
Is the, what you just described?
Yes, ma'am.
Is that in the record?
It is not. The defense didn't ask for it. I didn't think to put it into the record. We used it to summarize all the things that they had seen through the course of the punishment trial. So,
Excuse me, when you said earlier that there was no constitutional error, I asked defense counsel if the Eighth Amendment was invoked. Can you explain to me how you think it is not a constitutional violation under the Eighth Amendment? Can you address that for me?
yes. So I believe it's harmless under the constitutional, under the Constitution as well. The test for that is whether there was a reasonable possibility that it might have contributed to the jury's decision because of the overwhelming amount of evidence.
So are you saying that, I'm trying to figure out if you're saying that it is an Eighth Amendment violation, but it's harmless under the constitutional standard, or are you saying it's not an Eighth Amendment constitutional violation?
That's a tough question. I know it's improper.
Okay.
Whether it's a violation of the Eighth Amendment, I don't think so. But
That's what I'm trying to, because in order to decide which harm standard
Sure.
which glass we look
Exactly.
through, we have to decide, does it violate the Constitution?
so my answer would be no.
Okay.
It does not. Whether the slide and the comments contributed to the jury's decision, again, we had the overwhelming amount of evidence. The question was raised a few moments ago, and I'm sorry I didn't make a note of which judge asked. The degree of, or the amount of the conversation. I put in my brief, it was very small. It was 4 lines of the transcript, 4 lines on 15 pages worth of closing argument. And so it was very small. As soon as the objection was made, we moved on and we did not address it again. All of the arguments made by myself after that point and by my co-counsel specifically focused on a plea for law enforcement and not other debt officers.
How long did the slides stay up?
A minute, maybe? I speak pretty quickly, as you can tell, and so I was pushing through because I was trying to make sure we got all of our time done.
Counsel, I assume in voir dire there were questions to the prospective jurors about their thoughts on law enforcement, relationship to law enforcement. Is there anything there that you could point to that perhaps demonstrated that this would not have had such a great impact on the jurors that were selected?
Not that I can speak to, I'm sorry, that was a long, many, many days of individual voir dire, so I can't think of anything specific that I can offer, I'm sorry.
Okay, sorry,
So
thank you.
you do have the transcript, but I don't have that answer for you.
Thank you.
So what the courts tell us and what you all have told us is that you are going to evaluate this, the entire record in a neutral manner and not just in a light of favorable to the prosecution, and we fully expect that. Again, it was a stupid mistake, regrettable from the moment it happened all the way to standing here today. It was not the thing to do. But I still believe that it was harmless under both standards, non-constitutional and constitutional. Are there other questions about that point that I could answer for you? Okay. Moving on to the lesser included points of error 1 and 2, I did file the bench exhibits on Monday for you. Yes, we spent a lot of time during our presentation to the jury of the evidence, making sure that a Nueces County jury understood the mindset and the protocols and the culture of a West Texas Deputy Sheriff's Office. They don't dress the same way that people do in Nueces County. We moved this case all the way from Upton County to Nueces County, and we were concerned that the jury might not see things the way that would be fair to us from the standpoint of their officers are all in uniforms. They have their expectations would be different than West Texas.
Sorry, doesn't that sort of feed into the argument the defense is making? Like, if you had to educate the jury so much about why these people should be regarded as law enforcement, doesn't it make it seem more reasonable that maybe it's easy for someone not to know that the guy was law enforcement or the victim was law enforcement?
The appellant was from a small town also. And it wasn't a West Texas town, but he had been in West Texas before. So I would disagree with that characterization.
Okay.
That we were concerned that the big city folks wouldn't understand the small town mentality.
And isn't the real question whether they had enough on them to demonstrate that they were actually law enforcement?
Yes, and if you'll look at the exhibits, Deputy Kennedy had on a shirt that had an embroidered badge. He had on his duty belt that was obvious, and I gave you 3 pictures that show him walking into the store. These are the store video pictures, stills. He had the badge on his cap said sheriff in big bold letters, and the back of his belt had his handcuffs and all of that. So it was very obvious. The vehicles that they pulled up in also were marked on every side. I gave you a view of every side of his vehicle. And Deputy Stiles had on a cowboy hat, which is a little more common for West Texas than the sheriff's cap, but the sheriff's cap did clearly identify Deputy Kennedy as a sheriff deputy. And Deputy Stiles had his radio strapped across him with the mic up here on the sleeve and the cord across his belt.
So your argument is that they were entitled to the instruction, but that shows that it's not harmful, that it wasn't harmful.
I'm sorry?
Your argument is that it's not harmful, that he didn't get the instruction, or that he shouldn't have got the instruction at all?
I'm going to answer your question this way. I don't believe there was a scintilla of evidence at all, so the instruction was not necessary. It was not required. Judge Hurd's comment when the defense asked whether she was going to include a lesser included, her statement was, from the state of the evidence, I don't believe it's necessary. I'm summarizing. And basically she said somebody has to ask first, but based upon the evidence, I don't think it's necessary. So she was astute and paying attention. She had years of experience on these kinds of cases, so I know she was tuned into that as well.
But even if we assume that the instruction was warranted, you would argue that it was harmless not giving it?
I'm sorry, the last
Even
part?
if we assume that the instruction was warranted and should have been given, you would still argue that it's harmless?
I do, yes.
The lack of the instruction was harmless, sorry.
I'm sorry?
The lack of the instruction was harmless?
Yes.
Yeah.
Yes. I don't think it was necessary at all. The evidence did not raise anything that would warrant it. I've been reading some of your cases, trying to get a feel for your opinion on this, and I was surprised to learn that the state, from one of your opinions, has basically an automatic right to a lesser included if we ask for it. That might be the opinion, but in some courts, that's not always true. Yes, we do ask for it when the defense has beaten the tar out of our witnesses, and we feel like the state of our evidence has been decreased by that cross-examination, and we need a fallback plan for the jury. So yes, we do ask, but we're not always granted that. So asking by the prosecution does not always mean that we get it. I don't think it's statutorily required, and the judge is going to weigh what he or she believes should or shouldn't be done. So
You didn't ask for it in this case, though?
I did not.
Oh, fair enough.
I did not. I didn't think it was warranted, and so we stood silent and then told the judge during our part of the response, we didn't think it was warranted. That's really all I have unless you have some more questions.
Thank you, counsel.
Yes, thank you.
Your Honors, the death of Deputy Kennedy was undoubtedly tragic, but it is particularly in these tragic cases that the safeguards of our criminal legal system must be carefully observed in order to ensure that jury verdicts and sentences are based on reason and evidence rather than passion and emotion. This court has described the purpose of closing argument as to facilitate the jury in properly analyzing the evidence presented at trial so that it may arrive at a just and reasonable conclusion based on the evidence alone and not any fact not in evidence. The state's...
Counsel, did the judge instruct the jurors that statements by the attorneys are not evidence?
Your Honor, there was no admonishment right after this objection. I have not reviewed the punishment charge to see that, and I can submit a post-submission brief if you would like. But there was no response at that time, and I think that the overruling of the objection with nothing else suggested to the jury that this was not an improper argument at all. However, the introduction of this inadmissible extra record evidence, the act of others, the invocation of a patron saint of law enforcement and passing that torch onto the jury physically, invoking the other families of other fallen law enforcement officers, arguing that the jury should not let them down by sentencing this defendant to life without parole, and the suggestion that defendants convicted of killing law enforcement officers don't get life without parole. This was thematically powerful, and it was exceedingly improper. In this context, powerful is prejudicial. This court has recognized the impropriety of this sort of argument and reversed cases even with instructions to disregard. In Lopez versus State, as we cite in our briefing, in Escobedo versus State, as we cite in our briefing, and in many other cases. Because this carefully crafted theme played directly to the highly charged through line of this case, the death of a law enforcement officer, and because the jury may have had a reasonable doubt as to the knowledge element at the merits phase, it affected the substantial rights of the appellant. It cannot be disregarded, and the state certainly cannot meet their burden to prove this error harmless beyond a reasonable doubt. For these reasons and the arguments and authorities cited in our briefing, unless there are any further questions.
One more, if you know, how long did the jury deliberate?
I don't know off the top of my head, Your Honor. I apologize.
Thank you.
But this argument, was that punishment?
Punishment.
right?
Yes, Your Honor.
You just made a comment that they would have a reasonable doubt as to his guilt. Well, they'd already decided
Well,
guilt. right?
Yes, Your Honor, but they were not given the requisite lesser included offense instruction to express that reasonable doubt had they had it. So the precise concern of Beck that a jury might compromise towards conviction was present here.
So are you saying that if a jury might have had a reasonable doubt about the greater offense, then the lesser included offense has to be instructed on?
This court's cases say that if a jury could rationally have convicted on the lesser only. So I think the inverse of that would be that they may have had a reasonable doubt as to the greater. Yes, Your Honor.
So as long as they have a reasonable doubt or could have a reasonable doubt, the defendant's entitled to the LAO instruction.
And there is a scintilla that would support conviction of the lesser, yes.
Well, as long as you prove the greater, you're always going to have evidence of the lesser, right?
Well, right, and
So
the
that's
court,
more than a scintilla.
yeah, well, the court has used the language of lesser only. So if there is evidence on which they could convict, a rational jury could reasonably convict of the lesser only, that would suggest a reasonable doubt as to one of the elements of the greater.
Okay, thank you.
Thank you.
Thank you, counsel.
Thank you.
The case is submitted.